Cool. So one more time, hello to each of you guys. Just do a quick review on what we had in the previous session. Specifically in our tonight class, I will talk about copyright in a little bit more in detail. Also, I remember from the previous session, I wanted to show you a video as well, but we didn't have time for it. So tonight I will show you that video about the different types of intellectual properties. We had a chat in the previous session about the challenges of dealing with intellectual properties. Intellectual properties are properties belongs to mind or creating creativity of mind. In the previous session, we firstly have a chat about why we need to know about intellectual property, why we need to know about copyright, licensing, and etc. And as you remember, when you start your job in IT, automatically you might be involved with so many different types of intellectual property. So it's very important to be aware of our responsibilities, to be aware of definitions and types of intellectual properties, which might be even a few lines of codes or scripts that you may use it for a part of your report or a program. As discussed in the previous session, everything in IT involves intellectual property, licensing, and copyright. In our tonight class, we will talk more about open source, closed source, copyright, and copyleft, and public domains, and what type of legal risk we may face if we just go and search something in Google and we assume because Google show those results to us, it means we are allowed to use those things. So I will talk more about this in our tonight class. Legal risk obviously is the first reason. Cybersecurity, as discussed in the previous session, is nothing, just the ethics and privacy protection. Later on in cybersecurity, specifically for units like penetration testing, we see this importance. So there is a very, very invisible border between hacking and penetration testing, and that's having a permission. If there is no permission, written permission, of course, then a penetration testing activity may become a cyber attacks. Also in penetration testing, later on we will see, even with having a well-written agreements, still there might be areas that the penetration tester testing team they goes out of the scope, or they may go out intentionally or unintentionally, they may go out of the scope of their testing. Cyber jobs, they require finding non-compliance. It's very also common to go find non-compliance issues. In order to do that, we need to know about the intellectual property. So these topics are linked directly to your real jobs. Every day in IT, you will deal with this kind of thing. Also, we had a chat about policies and procedures. We had a look on a couple of different examples. A policy like having a strong password. So policy is mainly talking about why. Procedure is mainly talking about how. For example, setting and a strong password. It might be a policy. But how to do that? There might be a couple of different things like combining uppercase, lowercase, symbols, numbers, the length of a password, the frequency of change of the password. All of those things might be the procedure on how to set up a strong policy. Also, we had a chat about, as I said, physical assets and financial assets. I explained about the each of these types of assets in terms of the pricing, in terms of moving the ownership, in terms of the challenges that we may face in pricing, protecting, and converting the ownership. Copyright was one of the things that we discussed in the previous sessions. It's one type of intellectual property. It protects the creations of mind. I will talk more about copyright in our tonight class. And it's an automatic thing. It means once you create something, which might be right off a couple of lines of code, it might be an script, it might be a flowchart or whatever, copyright automatically protects you. Patent also, we had a chat about patent in the previous sessions, protects inventions or new methods. But as discussed, we need to apply for it, and it's not free, it costs. Unlike copyright, patent needs application. We need to apply, and till getting the protection, we need to keep it as a secret. We will talk more about patents also in our tonight session as well. Trademark was another type of intellectual properties. Anything to identify a brand, like a logo, like a brand name, like a packaging, like a design, they all might be some types of trademarks. Now what I want to do, I just want to have a more chat about the copyright. We talk about the copyright. and Copyright Act in 1968, which is an act designed to protect the rights of the owner. Let's do have a more in-depth chat about the copyright. When it's free, when we are allowed to use copyright, or what we call it as fair use of copyright. It's a topic that I'm going to talk about it. But as discussed, a copyright will protect the creations of mind. This definition is very important. Let me to write it down again. So copyright, what it does, protects creations of mind. Like what? Like a software code. Imagine that you write some codes, copyright applies to it. It might be a script, it might be a photo, it might be an image, it might be a report, it might be a document. Imagine, for example, you create a report for your manager, you create a report for yourself, or for example, you create a UI design, training materials, video, audio, whatever you create, copyright applies to it. For the previous unit, a couple of you guys, you uploaded video, for example, explaining how to back up a Windows server, how to create a new user, how to create a user group. All of those videos that you created, copyright automatically applies to those videos as well. So it's an automatic thing and you don't need to register it. Copyright Act automatically applies to you. It's very, very important. But if I want to focus more on this and see why this definition is important, because there are some things that copyright doesn't protect. Not protected by copyright. Again, let's read this definition one more time, then to move to why some items might be not protected by copyright. Copyright protects creations of mind. But if you just have an idea in your mind, copyright doesn't protect your idea. It's in your mind. It needs to have some conversion in reality. Otherwise, your ideas, your thoughts, concepts, methods, they will not get protected by copyright. For example, I cannot say, I was thinking about an application or I thought about a software. No, just thinking about an application, just thinking about just having the thoughts of an idea, it doesn't get protected. It doesn't protect you with the Copyright Act. Again, if I go back to the items that it gets protected by copyright, it was like a software. It means that it's written. It's something that you can see. It's a bunch of codes. It's an script. It's an application. It's a document. It's a website. It's a video. It's a song. It's a logo. It's a graphics. It's a chart. It's a e-learning material. It's something that has been created, not just being in my mind. So ideas, thoughts, concepts, they are not get protected. I cannot say I had an idea of making a laptop. So if there is any company making a laptop, they have to pay me because I had that idea. Okay, I had that idea, but I never had a chance or I never had the ability to turn it to something. So just having an idea, just having a thought, just having a concept, it doesn't mean that I can get protected. Also, as discussed, copyright is automatic. It is automatic. As soon as you write the code, as soon as you create a video, as soon as you create a song, as soon as you design an application, a logo, a UI, a chart, a diagram, whatever, it's protected. So when I create a chart, when I create a video, copyright. When I have the idea, it's still in my mind. So there is nothing that can get protected. But when it turns into something, when that idea comes down in form of a photo, when that idea comes down in a chart, in a report, in a written document, then it's automatically gets protected and I don't need to apply for it. Why this might be important for us as a student in IT or in cybersecurity, why we need to know about these copyright things. Highly possible in our studies, later on in our jobs, for example, I might be interested to go and copy someone else's code from GitHub. So it's a violation of copyright. I just go to GitHub and I say, oh, there are a couple of lines of codes and I copy from someone's GitHub. So it's a violation. I may use an image or a song, or for example, a part of a report or a part of a book in my project or in my report that I'm going to send it to my manager. So it's a breach of copyright. Later on in cybersecurity, we may use, today I will talk more about them, we may use some license tools. So if there is no permission, it's not legal. It's an illegal activity if I modify licensed tools. Today, as I said, I will talk more about open source and closed source tools that we may see in IT. For example, sharing some commercial software. There might be a software and I have a Discord group or I have a WhatsApp group and I'm sharing some commercial softwares on Discord. So it's a breach of law. Or imagine, for example, it might be an internal company scripts or configurations. So I just use it for my personal purposes or for personal usage. Again, all of those scripts, all of those configurations, it belongs to my company, it belongs to my employer, and I might be under violation of IP. So if you just put yourself in that position that you work somewhere and you want to create a report, in your report, you want to use a chart or you want to use some photos or some other reports from someone else. So be very cautious. You might be unintentionally be under violation of Copyright Act. And again, as I said, copyright, it protects the expression of an idea, not the idea itself. The expression might be in different forms as discussed. It might be a movie, it might be a song. It's not just idea purely, it's the expression of that idea. Cool. So now that you are familiar with what copyright protects and what copyright doesn't protect, you know that when you're using a software, when you are using or referring to a website, when you are using some documents, when you are using training materials, when you are using diagrams, videos, images, sound files, databases, all of those things, we need to make sure that we are not under violation of copyright. For example, if just to wrap up this topic, imagine that you write a code for a password manager, what we had in our programming unit. So you write the code to create a password manager, to create a password strength checker. If you just have it as an idea, you just think about it, you say that in my code, I will do this, this, and that. I will import these libraries. I want to have these functions and these features. If it's an idea, it's not protected. It's not copyrighted. But if you just write the actual scripts, wordings, pseudo, charts, diagrams, UIs, anything which is an expression of your idea, then that moment you've been protected. And obviously, copyright plays a very important role in every technique and every side of our business. For example, if you might be or if you're interested to be a software developer, website developer, be very cautious about using scripts, functions, and algorithms. If you're using open source tools, I will talk more about them today, like Nmap, Wireshark, Linux, Metasploit. In my previous class, I show you Metasploit environments. They all have license, so we need to be aware of that. When working in cybersecurity, for example, sharing copyrighted reports, using cracked tools, reposting some commercial threat intelligence without getting the approval, when creating documentations or training content, creating reports, screenshots, diagrams, incident response procedures. You cannot take images or text from the internet without getting the permission. As I said, even if you search it in Google and you find it on the web and it's free and nothing stops you, it doesn't mean that I'm able to use those reports or incident response procedures. I need to have the permissions. Otherwise, I might be on the violation of the act because it might be licensed under Creative Commons or CC that we will talk more about it. Okay, cool. So let's move on and see what might be the cases. Let me choose another color. This one. When, let's use another color, sorry. When we can use copyrighted material without violating copyright. There might be situations that we can use the copyrighted material, but without being in the violation of Copyright Act. Probably you will see something like fair use or fair dealing. One of the scenarios that we may use copyrighted material without being under violation is for educational purposes. It might be very important for us as students in IT. So when we use copyrighted materials for a study or for classroom activities, it's used only for our assignments. It's only used to learn the topic. It's only used within the class or within the LMS systems, within Video Collaborate. So we are not in the violation of copyright. For example, there might be a video. You see that in my classes, usually I play some videos that you can find those videos on YouTube or you can find them in some other platforms. You see, and you know that sometimes I use those videos. Okay, because I'm using those videos only for training and education purposes. I'm not on the violation of privacy, pro copyright rule. Imagine, for example, I use screenshots of Wireshark captured in an assignment using a diagram from Cisco or Microsoft in my training content, in my assessments, in my documents that I'm sharing with the class, using an screenshots of a code in an educational exercise. Copying, for example, and a small extract from a textbook for a study. In all of those situations, because I'm using those copyrighted material only for education and training, I'm not in the violation. But even in this situation, I should be aware of something. Uploading the copyrighted material to a public website. I cannot do that. Selling or publishing the content. For example, this class recordings, obviously it belongs to Victoria University, but imagine that I create a YouTube channel for myself and I use these class recordings and I upload it in my personal account in YouTube. Obviously, it may have some financial benefits for me. So selling or publishing this content, I'm not allowed. As you see, it's pretty tricky. I'm the owner. I'm creating these class recordings, but it doesn't belong to me. It belongs to my employer. Or imagine I use some other materials that they might be copyrighted. I use it for, I don't know, my assignments or for content. That's okay, but later on, I upload it in my own weblog. I upload it in the public websites. So sharing these commercial training materials outside of classroom is not allowed.
Sorry.
Yes.
If you want to share it in a private, for example, group in WhatsApp or Telegram that you have created it for your students, for example. If you share, for example, this material, these copyrighted materials in this group, is it a violation?
Ah, yes, I cannot share it in my personal account. Yeah.
Oh, even a group, even a group that you have created it for your students, for example, for this course.
So in order to create any group, I'm not allowed to use any personal account or I'm not allowed to use any personal email. As you see, all of my communications with you is with your student email and with my staff email. So yeah, technically I'm not allowed to use university content, even if it's created by me. Heaps of the content that you will see in certificate 4, it's created by teachers, including me. But I'm not able to use it in my personal account. I'm not even able to use it in my other class. Imagine that I teach here in Wikini and I teach in Deakin University as well. If it's created here, it's created by me. I was the owner and I was the SR creator. I'm not able even to use it in another education environments in another institute. Yes, because
No, I mean the material, the copyrighted materials that that you use, for example, for educational purposes during your course, for example.
Mhm.
Can you share it in this group? In this group, it's not a public group. It's a group that is created by you for your own students and for this course.
Okay, so if for example I created a group, imagine I may create a group in View Collaborate. Yes, I can share it. But
Oh,
again,
you
yes,
collaborate.
yes, it might be something relevant to, it's not my personal account. Again, I created the group, but it's not my personal. I'm not sure if I answer your question or not.
Yes, yes, exactly. You're answering my question.
Okay, cool. Good.
So this group should be for View Collaborate group. Yes.
Yeah, it should belongs to Victoria University group students. Yes.
And you can use all the copyrighted materials during your, for example, teaching activities, or
Yeah.
there are some exceptions.
No, yeah, if it's just for, as I say, if it's only for education, then I can use it. Yes, that's okay. Even if it's copyrighted, because I use it for only learning and for education purposes. Yes, I can use any copyrighted material.
Okay. And can I ask another question?
Yeah, sure.
For example, I completed a course in a field, for example, such as AI, for example,
Hmm.
which is provided by, I don't know, an institution, I don't know, such as Coursera, for example.
Hmm.
If I want to know if I'm allowed to, for example, provide a course in the field of AI based on the curriculum of the course that I participated and completed in AI, for example, in Coursera, and teach this course, for example, to my students in the university. Is it allowed or no?
Okay, so that's a good question. Imagine that you learn something. For example, I go and learn something from Coursera or Udemy or any other
Yes.
platforms. There might be some contents like PowerPoints that you can read it, or content in terms of PDF or Word or whatever. If I just go and read it for my own study and based on my knowledge, I create my own delivery, I create my own content, that's totally fine. But if I use the same content, for example, it might be a PowerPoint presentation, I download it from Coursera because I've been a student in that course, and then I use exactly the same copy, exactly the same material, and I just go and start using it, I might be under violation of copyright. And heaps of those times, it's explicitly tells you if you are using this PowerPoint or if you are using this PDF, it's only created for you as a student. You are not allowed to reshare it or redistribute it under your own name. But if I want to explain it in a simple, imagine that I go, for example, learn a course in Udemy, Coursera, whatever. I'm not using all of those contents directly, but it's coming from my own knowledge. That's okay. That's the case that I'm learning from those content. But when I go to another class, when I create a video, when I create a podcast and I want to put it in my YouTube or I want to distribute it even for financial purposes, if it's not a direct copy from those content, that's okay. But if I'm exactly using those PowerPoint, those PDFs, those content, those videos, yes, you are under violation of copyright.
No, for example, in these cases, you create your own PDFs, but they are
That's
based on the
okay.
curriculum of this course, for
That's okay.
example.
It's created by you.
Oh, so that's not a problem.
No, that's not the problem because you are the owner, you are the creator. But I got ideas from that channel, I got ideas, I got layout. That's okay.
Okay. Thank you.
No, it's a problem. Yeah, that's okay. You can use that. And that's what we do. We learn from universities, we learn from YouTube, we learn, but we create something new.
And my last question, sorry.
That's it.
If I want to share it for public, for example, I don't know, in your group, in your own, for example, a group, for example, or channel, for example, if you reference it, that, for example, you have used it from this book or this paper, for example, it's the same thing that we are doing in publishing papers, for example, in the introduction part of the paper, for example, we reference to different papers, for example. Is it allowed to do this? I
Yeah.
mean, for example, we can share part of a book or a paper and we reference it, for example, we mention that this is referenced in, for example, this paper or this book.
Yes. As you see in my board, that's exactly what I'm going to talk about it. Yes, it's allowed, as you see, fair dealing for research or a study. So, for example, imagine that you may copy not the whole book or not the whole report. I'm, for example, creating a new report. In my report, I can use a reasonable portion of another report, a reasonable portion of another research or another book or another written documents. It's only for the learning, it's only for the research. Yes, if you provide appropriate referencing, there should be no issue. So in my
Oh,
report, that's what we do in our master or in our PhD, when we want, for example, to go to the history of the research to say what's done in the past. Yes, obviously, I may go and reference a couple of different documents, but at the end of my reports, I explicitly mention this portion or this section. I need to mention it and I need to explicitly shows this paragraph or these two paragraphs are coming from that book or are coming from that research. So that's totally fine and it's not in the violation. Copying part of a
okay.
research paper or encryptions for an assignments, taking a screenshots of a cyber attack diagrams, that's done by someone else, but with appropriate referencing, that's totally fine. There is no issue.
Okay. Thank you. And if we want to use, for example, a software, a commercial software, for example, PSSC, for an education, for example, doing simulating, for example, something
Mm.
for educational purposes, not commercial or making money, for example. Is that okay or no?
That's okay. Yes, that's totally fine.
So we can use these
Yes.
commercial softwares.
Yeah, you
Okay.
can. Yes, definitely you can do that. Yeah.
Okay. Thank you.
Just another question on similar
Yes.
ground. Imagine you're learning from someone a
Mm-hmm.
method to solve a problem, for example, a mathematical problem.
Mm-hmm.
And then you go to another institute or somewhere, wherever it is, and start teaching and use that formulas to teach the student. Now, you are getting money out of it because you are a lecturer there. Then can you use that method or formula?
Hmm. So, for example, I get a formula from you, and then
Yes.
based on the formula that I learned from you, then I can go and
To a
earn
university or
money. Yes.
somewhere. Yep.
Okay, so it's a pretty tricky one, but because the formula it doesn't have any expression, so the formula, if you showed me something or if you talk about something, I don't know how I got your formula. If you write down your formula on a paper and I saw it,
Oh no, imagine I'm just attending a lecture and I got the formula from there. But I go somewhere else and start teaching that formula
hmm, I start teaching that formula. I reckon
and
it
I
shouldn't
get
be.
money for that.
Hmm. It's a pretty tricky one. Yeah, I should check. I'm not sure. So imagine that you come to my class, you learn something as a formula, for example, as you say. Based
Yes.
on that formula, Yeah, formula, I reckon it's not copyright. It might be a patent or it might be registrations. Otherwise, yeah, you can earn money out of it.
Yeah, because this we can push this idea to the idea of teaching itself. For example, I teach a chapter from a book, say one,
Hmm?
2, 3, 4, 5. That's the
Hmm.
chapter in a book, okay? 1, 2, 3, 4, 5. But when I'm teaching a class, I will teach 1, 2, 4, 3, 5. That means I'm jumping one chapter and going
Hmm.
back. Now that's a change in the technique of teaching.
Correct. I reckon it shouldn't be under violation of copyright
But
somehow.
but the method of teaching is my own because nobody has done that
Yes,
before.
correct. Yes. So you added something to it and it's created and regenerated by you. I reckon it shouldn't be under violation of the copyright.
And one more question, okay? Just going.
Yes.
The question is, you said that if you got an idea, it's a copyrighted, right? Uh,
Idea, if it doesn't have any expression, idea by itself, no.
no, but expression is I'm going to write that idea on a piece of paper. Does it becomes a copyright?
Yes, it's become a copyright.
Okay, because this is in comparison to patent. Patent is an idea which has not manifested into product or something, but it's still written on a paper.
Python,
A patent.
patent. Ah,
Yeah,
patent.
yeah.
So for patent, yes, for patent, it needs registration.
But
If I have
if
an
it,
idea, if I don't
no,
go
no, no.
and
I'm
register
saying,
it and someone get it and someone use it, so
yeah,
they used it before me. Yeah, it happens a lot that some people they have an idea, but someone else, before protecting it by the patent rule, they got that idea, they steal it, they heard it, I don't know.
uh,
I have an idea, I didn't register it, and I'm talking about it with you. Then you go and register a patent for it. So yeah, you are fine.
yes. So as long as you got idea and it is written down somewhere or registered somewhere, that becomes a copyright.
Yes. Copyright and patents are very close to each other. And
Yeah,
this area also is pretty tricky. And obviously, I'm not a judge to assess all of this because it happens a lot that companies or people, they might be in dispute that you stole that idea from me. Yeah, it goes to the court and then judge based on the documents and evidence and so many factors. They may decide against or in favor of someone. It's a pretty tricky area, as you see. There's so many cases, and I can't exactly 100% sure that, yeah, it should be a violation or not. But yeah, you see, it's pretty tricky and challenging area.
yep, yep. Thank you.
Cool? Not a problem. Okay, cool. So fair dealing for research or a study as discussed. Uh, just let me to put this down as well. So you may copy a reasonable portion. Again, this word, it's very challenging. Reasonable. What is reasonable and what is not reasonable? Again, in the cases that they took the case to the court, it's based on judgment, and the judge obviously needs to ask for different evidence and then make a decision if it's reasonable or if it's not reasonable. You see this a lot in IT and cybersecurity. For example, in our previous session, we had a chat about data breach. So imagine something happens, and then um, for example, in case of Optus data breach or other companies, you see the managers, CEOs, board of directors, they may ask to go to the court and they provide evidence and documents, and judge ask for reasonable effort. So this word is pretty tricky. What is reasonable and what is not reasonable? It based on so many different factors. If you may copy a reasonable portion, it's obviously not the whole portion or not the whole entire documents for research. If there is an if here, if it's for your own learning, for example, it's okay, not publicly shared, it's okay. As discussed, you may provide referencing. Should be okay. And yes, that's another case. Was there any other question? For educational use, fair dealing for research and study? Another, yes?
Yes. Sorry, this is very this in this session. In contrary to the last practical sessions, there are many questions. Sorry.
No.
Can we use, for example, so the information that we, for example, gain from ChatGPT, DeepSeek in commercial purposes, because we don't know that if they use the copyrighted ones or no, and if we can use this information
I think we
even
can
for
use.
commercial purposes.
Yeah, I reckon we can use that. Yes.
Okay, and it most of the time it happens. For example, in our presentations, if we want to find a sticker or a figure from, for example, an airplane or an accident or something, I don't know. We do a search on a Google, for example, on Google Images, and we find some media or pictures to use them in our presentations. I'm not talking about the educational presentations because you told that it's not important. But for commercial presentations, for example, can we use
Yeah, you
these
might be. Yeah, you might be under violation. You should check. Imagine
oh,
it was a good case. Yes, for example, you you download a
stickers?
photo. Yes, because the photo, yeah, there are so many cases. If you just go and search it, there have been a lot of cases that someone used some photos and then the owner complained. For example, imagine the photo in the background of Windows. I remember there was a case similar to that, that's a photo used for that commercial purposes. So yeah, it's highly possible. You use a photo, you may use, I don't know, an sticker or something just because you find it in Google and you use it for commercial purposes. Yes, you might be. You should check if that photo is available for free and if you're allowed to use it. But if it's something special, and you use it because it's nice or it's different and you're not aware that it might be on the copyright protections, yeah, it's possible. And if the owner knows about it and they go and complain, yes, you might be in the violation of copyright.
Isn't for the free PowerPoint templates, for example, that we can find them on the internet by a simple search on Google?
Again, it's pretty tricky area, but you said that you are using it for commercial purposes, for example, earning money or selling, it means commercial. Yes, you might be under violation,
Okay.
even if you find it
Okay.
in Google.
So it's very difficult. It
Yes, you need to be cautious. Yes,
makes it
that's the reason. Yeah,
difficult.
that's the reason that we have this unit. Yes, if you are creating a content, if you're and you want to sell it, you want to put it, yes, we need to check. All of us, we need to check.
You want, for
Photos are
example, to provide a proposal for for a commercial project, and you use some free PowerPoint templates from the internet. Is it for commercial purposes too? Yes.
free. If it's free, it's free. So if it's free, it just says that you can use it.
Oh,
But if you're
free the
you say
free templates
PowerPoint
on
template.
Google.
PowerPoint template, you mean?
Yes, the free PowerPoint templates that you can find them in Google.
I reckon it should be okay. Again, I need to check, but I should be fine, I reckon, because it's freely available. It means that the owner it's freely put it freely available for usage, so it should be okay.
Okay. Thank you.
Amir, I'll make a small
Comment?
comment.
Yes,
Yes.
for sure. Yeah, just go for it.
The question, when you said it's a reasonable, it's a reasonable use, and there are lots of litigations. Now, some of the litigation they are completely thrown out immediately once they are lodged. Yeah, they say
Hmm.
no, this comes under law, and it becomes very tricky when they are very close and cannot be decided. Now, especially various things like licensing of Google and with the web browsers and all those things becomes very tricky. Now, the question is always these big cases which go to the courts and the judge has to make it. Those are very tricky because they have got arguments on both the sides, and both the sides stick to their arguments. The question, and therefore it becomes the reasonable becomes contextual base. rather than something that is written in the law.
Yes, you're right. Yeah, as I said, I'm not 100% expert in this area because even as you mentioned, when it goes to the court, the judge also, they ask for so many, sometimes it takes ages to go check all the evidence, they consult
Yes.
different people. Yeah, if you just go and search in Google, there are so many controversial cases. It's not easy to say if it was reasonable, if it was enough, or if it wasn't.
Because in some case it could be financial gain, but in other
Yes,
case it
correct.
could be just reputational gain, which cannot be easily translated to financial.
I know, yes. I remember there was a case. If I can find it, I share it with you next session. And it was in the court for 6 months or 1 year, I reckon. And the consequence was like $100 million. I try to find it and show you. But yeah, it's not easy. It's not easy. Some areas it might be very tricky to judge if it's okay or if it's not. Yeah, I try
Uh,
to find that case study and bring it to the class. I can't remember what was exactly the case. Yes, Mahmoud, any other question?
Sorry for having so many questions. In
That's
some
okay.
countries, there are not copyright rules. For example,
Yes.
there are many countries. For example, they translate some of books published in other countries to their own languages. For example, in their countries without any permission from the author. In their own country, it's not important because they are living in a country without any copyright, for
If you
example.
bring it here, it's
But
into violation.
but for example, if this person travels into abroad, for example, can the author of that book, for example, make a complaint from this
Yes.
person in
Yes.
another country's jurisdiction, for example?
Yes, yes. The answer is a simple yes. Yes, I have.
Oh,
For
yes.
myself also, if you just go to some other countries, softwares that are very expensive, for example, a software, it might be two, $3,000 here in Australia. You go to another country and you can get it for $1 or even for free. You know,
Yes.
and I know what you mean because there are countries that you can go and get bunch of over 700, 800 softwares just with like $2, $3. Okay.
Okay.
So if you're
Yeah,
using the because they
exactly.
don't yeah because they don't follow the copyright rules, I know what you mean. So that's okay. But if you purchase those material, like it might be a CD or it might be a book or it might be something, and bring it to the countries that they are protected by copyright, you are under violation of copyright.
Oh,
But having said
yes.
that, copyright
Thank you.
is only valid if it can be enforced.
Correct. So in those countries, they don't
They
they
don't
don't care
enforce.
about.
Yeah, exactly. So there has to be two issues. One is enforcement, and second to be monetary benefit.
Correct.
You can
Yes, that's
enforce it.
correct.
If there's no money, why worry about it?
Yeah, that's correct. Yes, there are so many cases in other countries. You know, and I know as well. That yeah, you can just get so many
Because
things.
if
More,
Microsoft, yeah, if
I
Microsoft,
remember.
sorry, go ahead.
Yes, go ahead.
And so Microsoft want to chase a guy in the streets in say India or somewhere trying to sell a software for $1. Microsoft will think, how much can I extract money out of that guy?
A lot. I remember when I was younger, maybe it was in 20 years ago, there was a movie, Kill Bill. And
Yes,
it was in
I
the
know
US
that
cinema.
movie.
Yes, you know, yeah, it was in US cinemas.
Yeah,
And I had friends overseas that they had it and they could send it or email it or send it to you by a CD. In that point of time that I was in the cinemas, they had it.
yes.
They didn't care about the copyright. Yes, Microsoft, for example, here they earn a lot from subscriptions, but there are so many countries that they don't care about it. They just have the cracked versions. They don't pay any fee. Yeah, Microsoft knows about that, but they can't do nothing. Yeah, there are countries in the world that they don't care about the copyright. But now we are here in Australia, so we should care. Another item for fair dealing is for criticism. Imagine, for example, you may use a content if your purpose is to analyze, to comment, to criticize, to review. All of those cases, obviously, you're not looking for a financial gain. And also, you acknowledge the source. So that's okay. For example, quoting a paragraph from an article, like analyzing a code snippet in a cyber report with the credit. Again, it's okay. Showing a screenshot of a phishing email just for analyzing to criticizing the security weaknesses. That's again okay. So just let me to quickly put this down. Using content. You may use content to analyze, comment, critique, review, and you acknowledge the source. Okay. Another case, again for fair dealing, is for parody or satire. For example, for comedy, for humorous. So again here, I remember the case that I tell you. If you just search it in Google, you can find it easily. The case was in parody. They took it to the court, and it took ages for the court to decide if it was in the violation of copyright or not. But if you just go and search, you may use copyrighted content to create it's a very famous one. I don't know why I forgot about it. This, if you just search it, there was a case. The owner said that you are in the violation of copyright, and the other party used that content for parody, I reckon. They claim that no, it's not for copyright intention. We just use that for parody. Again, if you just search it into Google, you can find it, or critical content. It's pretty rare in cybersecurity anyway, but it's good to know about parody as well. Cool. So that's about the situation that you can use a copyright, and obviously using with permission. So if you have the permission, the owner explicitly gives you the permission, or the license allows you, so you can go and use it. For example, using open source code in your personal project. I will talk about open source now, but that's totally fine if you're using open source code in your project. For example, you're modifying a GPL license component, again, that's okay, you can use it. You're reusing a diagram if the creator email you the consent, that's totally fine. Also, I can see that Lane put something in the chat as well about Nintendo. Yeah, no, there was another case. If you search in Google, it was for a couple of years ago, and it was purely talking about parody, and they went to the court. It was a very disputable case. I tried to find it anyway.
Anyway, there's a very fine line between using it for parody uh, and denigration.
Mm-hmm.
So the question is, you say I'm using it for parody, but it could be to denigrate someone. You understand my point?
Yes.
Though it comes under different law, it comes under different law.
Mm-hmm.
Still, it is quite a fine line there. Like,
Yes.
like I think the Charlie Hebdo case in France,
Mm-hmm.
all these things, there are so many. I think even in Australia, there are lots of art cases
Yes.
with which parody, but still, yeah, it is taken. Yeah, it's dangerous area. Dangerous area.
Yeah, you're right. So, Paul Ward, let me see. Maybe it's that one. Let me have a look to see if it was that one. Start, let's see.
Yeah, Palworld basically took Pokemon's sort of characters
Yes,
and turned it into Pokemons with guns, essentially.
yes.
It was such a great game, but Nintendo didn't like it. But also, they only decided to sue after they released a patent in the
Mm,
US. It was
really?
literally like a month after they submitted or got their patent approved,
Mm-hmm.
and it doesn't make sense.
Mm. Yeah, it makes sense. Yeah, okay. Good. Yeah, there are so many. If you just go and search Google, yeah, there are so many cases of parody that they've been questionable. The other thing, what's the time? It's 6:30. So yeah, just to put it simple, again, as you see, the area is very complex and tricky in some scenarios, but obviously we just need to know for paid textbooks, we are not able to use those material. It's not legal or sometimes not allowed. Uploading course materials or this kind of thing in public websites, sharing someone else code from GitHub to put it in your own GitHub or share it somewhere else using commercial images without the permissions. Again, that might be the violation. Reposting an entire news article. A portion is fine, but if you just go the entire article using cracked softwares, again, the case that Mahmoud mentioned, which is very common. Some softwares are very expensive, and I had friends that they came from overseas and they had a bunch of softwares on a CD. And when I asked them how much you get that, they said, oh, for the whole bunch, it was like a package. It has a very nice package as well. In the package, it was like there was like 30, 40 CDs with so many softwares for IT, cybersecurity, engineering. And when I asked how much you purchased that, and he said $2, I think. I was thinking only one software, maybe over $100. So all of those cracked softwares, yes, the using of them might be under the violation of copyright. In the other side of copyright also, we have something named public domain. So
Even for educational purposes, yes.
yeah, because they are paid, yes.
Okay, thank you.
If you are using it only for yourself, it should be okay. But yeah, it's a violation because it's a cracked software.
Okay,
Okay.
thank you.
Not a problem. So domain, public domain versus copyright work. So copyright, you know that it's a default state for most of creative works. We know that we cannot copy without getting permission. We cannot modify without permissions, and we should follow the license terms. But in the other side, we have public domain. What is public domain? Public domain, this is content free for anyone to use. And again, for the copyright from the previous session, you remember that copyright has an expiry, which might be 70 years after the creation of the um, item, or it might be 70 years after the death of the creator. Then it's freely available. Public domain also, this is the content freely available for anyone to use. So works either the public domain, for example, when copyright expires, it becomes a public domain. It might be a book, it might be a movie, it might be a code, anything. So when the copyright expires, it becomes a public domain, which means it's free for anyone to use it. Sometimes, again, it's good for you to go and search in the Google. The creator gives up the rights. Voluntarily. Imagine, I remember there was a case, again, I can't remember, I'm getting old and I can't remember, but imagine someone, they found a medicine, for example, I don't know, something to cure cancer, which may have benefits for the whole people. So they voluntarily gives up their rights and they made it publicly or freely available for anyone to go and use it. Obviously, imagine if someone can find something to treat some type of cancer. They can earn millions of dollars out of it. But some people, just to be benevolent, or just to help the other peoples, they may give up using or gaining any financial gains out of those medicines or their rights to use it. Government also may release some specific content. So it's a public domain, and you can use it freely. Some examples of public domain in IT, if I want to name a few, like old, let's use another color, like old educational textbook, for example. Some government created data sets. Old patents, for example. Specifically in cybersecurity, I reckon it was in this class that I was talking about the top 100 or the top 1 million or 10 million common passwords. In penetration testing, we use this a lot, like public domain word lists for penetration testing. For example, we may have a database of common passwords, the top 1 million common passwords, and we want to use it in a password cracker, or we write it down a code just to go and crack the password just for testing and checking the security in a website. So you may go and use a word list for penetration testing. Malware datasets, public domain malware datasets. For example, you want to use it for cyber training. Public domain scripts. Used in automation. If it's public domain, then it's available to use it for free. What we need to do, what we need to make sure, what we need to check, again, as discussed, if Google shows it, it doesn't mean that I can use it. It's wrong. So we need to check if that item is copyrighted or not. The other things that I want to talk in this time that I have, it's talking about open source and closed source, which is very relevant to this topic. Open source versus closed source. Majority of the softwares that we may see and we may use, they are closed source or proprietary softwares. It means that they are copyrighted. Heaps of the time they have subscriptions and we need to pay, we need to get the permissions. We are not able to resell it heaps of the time or redistribute it or modify it. They are closed source. Firstly, let's go to open source to see what is open source and why it's important in cybersecurity. Let me to use another color. Or I reckon it's better to start with closed source first because it's more common. So closed source or proprietary. They are software owned by a company or by a person. Software owned by another entity. So why we named it closed source? The reason is the source code is hidden. They have a code, heaps of software or applications that we may have. They written in different programming language. In our previous unit, I had a chat about C, C Sharp, C++, that usually they mainly use in software development, and they may contain million lines of codes to perform a task. Accounting softwares, accounting systems, HR systems, inventory systems, they all have lines of codes, million lines of codes. So the source code is hidden. When you purchase a software, we don't have access to the source code. So as a user, I cannot see what is inside the code. I just use it. Just like I purchase a watch, I have no idea how it works, how many pieces might be in that watch. I just use it. I just use it as a final product. So user have only the compile executable software. Like Windows. Windows, it's a closed source software. We don't have access to Windows source code. Mac OS, Microsoft Office, Cisco iOS, Adobe products, Burp Suite. We don't have access to the source code. In the operating system, Windows is a good case. In phones, iOS is a good case. It's closed source. So the source code is not available. I cannot view or modify the underlying code. Heaps of the time, it requires a license. So you have to pay or you agree to the license terms and conditions before using the software. It's mainly controlled by the creator or the owner. Only the vendor can update it, modify it, or fix the software. And in cybersecurity, we say security through obscurity. Let me put this down with another color. So as an attacker, I cannot easily see how the system works because I don't have access to the source code. When I don't have access to the source code, it's hidden. Cool. So closed source, software owned by another entity, and the source code is hidden. They require licensing. What else? Controlled by the vendor. Okay, so those are examples. Microsoft, iOS, Suite, Cisco iOS, Palo Alto Firewall operating system, Adobe product. They all are different types of closed source. In the other side, we have open source. So open source means that you have access to the source code. But to use this color, pink. The source code is publicly available. So it means that anyone can use it, can view the source code. Not only they can see the code, they are allowed to use it, to modify it, to redistribute it, and to use it for free. Examples of open source might be Linux, it might be Android, Python, it's freely available. I forgot to put the examples here. So Windows, Mac OS, iOS, they all are closed source. On the other side, we may have Linux. So Linux, you have access to the source code, and then you can go change it, modify it, and create a new distributions or a new distros of Linux. I already talked about Windows in my previous unit for my own class, but just like Windows that we have Windows 10, Windows 8, Windows XP. In Linux also, there are different versions or distributions or distros. Like Ubuntu, like Kali, Mint, Fedora, and etc. Nmap is an open source. Wireshark, Python, open source. It's free. You just need to go to python.org and you can download Python. Apache Web Server. Metasploit. We use it a lot in cybersecurity. Unlike so many TAFE courses that you have the access to hands-on activities and practices, in cybersecurity and in IT, when we want to learn and practice, unfortunately, we don't have the playground. We don't have the facility to go and test. Imagine I want to go and learn some hacking tools. It's not allowed, and I'm not allowed to go and test over a real public websites. So how should I practice? We need to have playgrounds like Metasploit or Metasploitable frameworks. In cybersecurity, you will learn about it. It means that all of these softwares are freely available. So when we are talking about this open source, not only the source code is visible, you can freely use and modify it. But there are a couple of things that we need to be cautious. Firstly, free to use, or better to say mostly, most of the time, many open source tools, it costs nothing. They are free. You go to python.org, you download it, you don't need to pay anything. You go to Nmap, download it, it's freely available. You use Wireshark, it's freely available. So many of these open source tools, it costs you nothing. Community driven, that's one of the advantages of open source softwares. Maybe you ask why a vendor or a developer, why they may put a software that they spend too much time and money, why they probably need to put it freely available for everyone, because they can earn money out of it. They can close, they can wrap up their codes. Why they make it freely available? It's because of expanding their community. There might be thousands or millions of developers and security researchers to contribute to improve it. Again, just imagine the case of Python. Python is now one of the best, or I would say the best programming language. Why? Because it's free. When it's free, there are millions and millions of people in the world. They contribute, they create libraries, they expand it, improving the functionality. That's the case for so many other open source tools as well. So when they make it free, it means that there should be more and more people or developers to contribute to improve it. It gets bigger and bigger and bigger. Everyone will help to improve it. Again, just compare. I don't want to say which one is better. Just compare this Android and iOS. So there are so many vendors like Samsung, like Huawei, they all use Android. Google devices, they all use Android. In the other side, we have iOS specifically designed for Apple computers, Apple phones, and it's closed source. Linux versus Windows. Which one is better? I cannot say which one is better. Windows, it's a closed source operating system. In the other side, we have Linux. With Linux, there are so many distributions. I would say in web servers, it should be over 90% of servers running on Linux. Why? Because people are able to customize it specifically for their own. Imagine that you just want to go and purchase a burger and it only comes in one shape, in one size, in one taste. And the other side, you may have some flexibility in the open source to change the ingredients, to change the taste. So which one is better? They have their own advantage and disadvantage, but community driven, it's a very big main advantage of open source. Unlike closed source that they had security through obscurity, they have security through transparency. Transparency. Like, for example, in encryption, different encryption algorithms, they're transparent. We know how it works. There is nothing in a hidden box. All the formula, all the algorithm, it's clearly visible. So it works through transparency. Because the code is open, vulnerabilities are discovered much faster. And also cybersecurity or cybersecurity professionals, they can go and audit the code by themselves. But it doesn't mean that when something is open source, there is no rule. Licensing still applies, but how it's different. Licensing, sorry. So open source doesn't mean there is no rule. You must follow some basic rules. Let's discuss a little bit more on this. Some license rules like GPL, BSD, and etc. There are some rules that we have to follow. For example, I go and expand it a little bit more. GPL is one of the open source platform that you create another column. For example, GPL says it has a very basic rule. It says if you use an open source content and you modify it, and redistribute it, your change should remain open source. What does it mean? Imagine that I'm a chef in a restaurant and I have a recipe for my dish. If I share that recipe, if I don't share the recipe to anyone, it's a closed source. It's a proprietary recipe. It means that I'm not sharing the recipe. Just like for soft drinks, Pepsi or Coca-Cola, they have a formula, they don't share it with anyone. KFC, they may have a recipe, I don't know. All other companies, they may have a secret code or a secret formula or something like that. They don't share it. But imagine that I'm a chef and I have a recipe for some type of food, and I'm happy to share my recipe or ingredients to anyone. I just write it on a piece of paper and I put it on my website. Hey guys, look, this is the recipe, this is the ingredients, the amount of the ingredients, and how I mix it. Imagine you get that recipe and then you change it based on your own taste, based on your favorites. And it's good. People, they love it, they like it. So if you are using my recipe, you change it, you modify it based on your own favorites. Your recipe also should be open source. It should be freely available. You cannot say, I don't provide it freely available for public because your input, because your source code was freely and openly available for you. If you have any modifications, if you change it, and if you want to redistribute it, your change also needs to remain open source. Or for example, the other one that I talk a little bit out of the content of our, you need to talk about Apache, BSD, or GPL. Meet also says it allows you to modify and sell. So here we have sell. Heaps of these open source softwares or open source resources that might be available for you. They have a free account or they have free subscriptions with some limited features. But obviously, if you want to use it in a commercial or in enterprise environments, they may have uh, some premiums features that you have to pay for it. As I said, heaps of these open source resources are publicly and freely available to use, but there might be situations for enterprise usage or for big customers to get some extra features and they can pay for it. The first one that I had a chat, GPL, I just have a very, very brief chat about it. Later on in cybersecurity, you will learn more about it. GPL, it's standing for GNU. Let's use this column. GNU, General Public Licensing. Is one of the restricted open source licenses, and it's designed to protect freedom by keeping software open forever. Like a couple of the softwares that you may have it as an open source and freely available, so you can use the software, you can modify the software, you can redistribute it, you can sell it. As I said, and selling is might be pretty interesting because it's open source, and as discussed with open source systems, it should be freely available. But as I said, it may have some extra features that they need investments for the database, for maintenance, to provide extra features, and then they are allowed to sell part of their resources as well. This GPL, it's good also to mention this as well, is a copyleft license. So we have copyright, and for copyright, it's a C in a circle. Yes, that's the logo for copyright. We also have copy left with this sign. What is copy left? It means it's pretty similar to open to public domain. It means that if you modify the GPL software and redistribute it, your version also should be open source under the GPL. As I said, just like I have a recipe, I share the recipe with you, you change it, you modify it, and you distribute it. Your version also must be open source under the GPL. You should release your modified source code. You cannot close it. You cannot say, oh, I used that recipe, but because I changed it and modified it, now I don't want to share it with others. You cannot. You cannot close the source or turn it into your proprietary software. Anything built using GPL code must also follow GPL rules. Like, imagine that you use a Linux kernel and you modify it. Like Kali is a Linux operating system, but it's specifically designed for attacking for cybersecurity and for hacking purposes, and it's freely available. Other distributions of Linux also, they all under GPL licensing. Many security tools which runs on Linux, they all are GPL based. Let me put down this because it's important. So many, let's do write it down with another column. Many security tools run on Linux, and Linux is GPL based. And it means if you modify the Linux kernel or if you modify the security tools, then you must release your source code. So that's why Linux stays open source permanently. And as discussed, there are more and more and more and more distros and distributions are releasing every day, but it's still free. And after a while, they have a big community will grow around this type of open source softwares. More and more people, because it's free. So when it's free, I simply go and use it. When I use it, I notice that I'm able to improve it. I'm able to add some extra features here to modify it. So I do that, and it keeps helping them to grow more and more and more. Exactly the same things in Android. If you just remember the history of operating systems in mobile phones, I remember when I was younger, there are so many different types of open source for Nokia devices. If you are old enough to remember, Nokia devices, they had their own operating systems called Symbian. We had Windows Phone. We had some other operating systems for HTC, for BlackBerry phones, they all disappeared. Now we have only two main operating systems, which is iOS for Apple phones and Android, that you can find it in so many different brands like Google, Samsung, LG also used to run their operating system. But for example, Android in Samsung phones is specifically modified and changed to be compatible with Samsung hardware, Samsung devices. Another brand, they can use the same base core and then add it some extra features or modify it or customize it based on their own requirements. So that's the GPO. Let me also to show you that video that I was talking about it. And in the meantime that you see the video, I will update the attendance, and I also have a look on your messages in the chat box as well. Let me to quickly share my screen to have a look on that video. Let me find it. Yeah, let me share my screen. So in this video, you can see different types of intellectual property. This video has been created by IP Australia. Share my screen.
Whatever business you're in, to stay ahead of the competition, your creativity, ideas, and innovations are crucial.
And much of that is intellectual property, or IP for short. Whatever business you're in, IP is your business.
Small business owners and inventors are busy. Many don't think about IP until it's too late. Only 1 out of 7 people understand the basic IP concepts in this video, and these are things that can help you avoid simple, costly, and irreversible mistakes. For example, did you know that registering your business name offers no protection for your logo or brand?
So what can IP do for your business? IP helps you make money and manage risk, usually over a set period of time. There are 6 different types of IP. Some require registration, while others are automatic. How many do you know? Patents for inventions, trademarks for brands, designs for how a product looks, plant breeders' rights, copyright for creative works like books, music, and art, and circuit layout rights. Let's take a look at the 3 main registered rights as well as copyright. These are the common types of IP you may encounter.
A patent is an exclusive right to commercialize or license your invention for up to 20 years. As with any registered IP, you should apply for a patent in each country where you'll be doing business. Registration is not a rubber stamp. You have to meet a set of criteria. It has to be new, inventive, and useful. New means no one else has already invented it. You must keep it secret before you apply. If you've already gone public with your invention, you may not get a patent. By inventive, we mean skilled people in your industry would not find your invention an obvious thing to do. Finally, your invention must have a useful function and actually work. It makes sense.
Let's move on to trademarks. A registered trademark protects your brand or logo. Registration can last forever, as long as you're using the mark and paying renewal fees. Unlike patents, trademarks don't have to be new. They don't have to be a secret, but they do have to be capable of distinguishing what you sell. You can't own descriptive words or symbols that other traders legitimately need to use. And it must not be so similar to anyone else's trademark for similar goods and services that customers might get confused. A registered trademark, business name, and domain name are 3 separate things to consider, especially when starting a business. However, a trademark is the most valuable because it proves ownership over your brand, and your brand is what customers use to identify your products.
A registered design is a bit like a patent, but lasts only up to 10 years. Where patents protect how a product works, a registered design protects how it looks. A design must be distinctive, where customers can notice the difference in how your product looks. Like patents, it has to be completely new. Keep your design a secret if you want to apply for protection.
Designs protect industrially manufactured products. But what about the original plans for that product? That's where copyright comes in. Copyright protects original creative works such as drawings, books, art, drama, music, software, and audiovisual recordings. Copyright is an automatic right that lasts for 70 years after the death of the creator.
You don't need to register your copyright with any government agency.
As with other IP of fixed length, like patents and designs, once copyright expires, no one owns it.
And anyone can freely copy it.
Visit ipaustralia.gov.au for more information.
Cool. So that's all. I updated the attendance as well. Let me to stop recording.